Hi there. My name is Jennifer Acosta, and today I will be presenting legal issues in kinesiology. I'm going to start with the topic that I chose, and that is commercialized gyms. I specifically chose commercialized gyms because I have a background in working in several of them. For the past 15 years, I have been a personal trainer, and for the last 8 years, I've been a fitness instructor. I have seen and experienced pros and cons of working in a gym facility. And to be honest, a lot of times, most employees do not know what legal recourse to take, if any, when it comes to certain legalities dealing with employers and workers and so forth. And neither do most members. So this class and assignment, I really gained the knowledge and learned specific legalities when it comes to working in a commercialized gym of what the employer should and should not be doing, and same with the coworkers and myself. Obviously, some of it is common sense, and others there's a fine line between what employees should be knowing and what employers keep away from their employees. So this class has really taught me a lot in that aspect. Going into risk management, I'm going to discuss three legal rulings regarding risk management in a gym setting. The first one will be trips and falls. The second one will be personal trainers, and the last one will be exercise equipment. I chose these topics because they are all specifics of what has happened or what can happen in a commercialized gym setting. So my first topic, trips and falls, we look at this case here with Kirk Anderson versus Fitness International LLC. This case, the plaintiff filed a gross negligence suit against LA Fitness because he had fallen several times inside the showers and had brought it to LA Fitness attention. The last time he fell, he did break his humerus in two places, had to have surgery to repair it with plates and screws, and filed a formal complaint and let them know um, what had happened to him. And after his recovery, about less than a year later, he returned to LA Fitness to continue to work out and went into the shower room and saw that nothing was fixed. They did not have railings. They had not added shower mats. There was no friction strips on the floor. So he took it upon himself to file a formal complaint and of gross negligence. Unfortunately, the courts did not see it in that manner, and they labeled it as ordinary negligence. And so I think in this situation, um, the best way to avoid this scenario, and unfortunately it does really happen, is by creating good housekeeping, reducing wet or slippery surfaces, avoid cluttered aisles and hallways, wearing proper shoes, and adding the proper railing, shower mats, and safe flooring. Um, because LA Fitness wasn't found to be guilty in this incident. However, if something was to happen again in this same facility, knowing that they've been to court already once, um, it's more than likely that the courts would find them responsible for not making those necessary adjustments and changes. The second topic, personal trainers. Being a personal trainer can be exciting. Being able to assist clients achieve their fitness goals, it's very rewarding. Just like any other job, it has its challenges. However, it is amazing to see the accomplishments of your clients, and you know what they're capable of doing, but just seeing them start believing in themselves and knowing that they are actually capable of doing and reaching their goals, it's really a really good feeling. Unfortunately, injuries can occur, like in this next case, Patricia Evans versus LA Fitness. The plaintiff, Patricia Evans, claims that it was her personal trainer's fault that she fell. She fractured her wrist from running. She was doing suicide drills, and her personal trainer was encouraging her to run a bit faster. And prior to her personal training sessions, Patricia Evans does have to sit down and um, fill out a contract for her personal training sessions. And in that contract is a liability waiver. And because she had signed this liability waiver, the judge in this case, Anita B. Brody, she did not feel that it was LA Fitness or the personal trainer's responsibility for her uh, getting injured. Was she volunteered to join, excuse me, in this activity, and so therefore LA Fitness was not held responsible. So in this situation, it's tough because unfortunately sometimes an injury can come with working out. Being a trainer, an athlete, your random Joe, you could just be doing the smallest thing and you pull a muscle, strain a muscle, you drop something and you break a bone or fracture. So in any incidents, unfortunately in this situation, an injury can occur. When you're with a personal trainer, you more or less like to think that you're safe, and for the most part you are. However, it is not 100% guaranteed. The most important thing that a person can do when working out is really listen to their body. Their body will tell them how they're feeling. They just need to really pay attention. And as far as the trainer goes, it is the trainer's responsibility to get to know their client. That's the most important thing. Running a fitness assessment. That's how you get to know your client. That's how your client gets to know you. But that is how you are able to determine where your client is at physically, medically, and where their strengths and weaknesses lie. Age age can be a factor. However, depending on their activity level, it may not be. And so it's okay if we're pushing, a 55-year-old who is typically healthy and good shape and has been working out. Um, but we also want to make sure that we listen to our clients when they're telling us something doesn't feel right or their muscles are really tight. We want to make sure that they're properly warmed up and so forth. Another key factor here is do not train beyond your knowledge and capabilities. And as harsh as that might kind of sound, but if you have a client that has a medical history that is beyond your experience, it is better to refer them to someone who can provide them the service they need. But in doing so, research about it, learn about it. So if you have a client who had a stroke and is gotten their mobility back, but you're not certain on what mobility and what exercises they should be doing, and you're not comfortable with training them, it is okay to turn them over because the client is there for them in their best interest in becoming healthy and mobile again. And then the next best thing that you can do is research, study, learn about it, ask your senior trainers for advice and input on how to be able to train somebody in that scenario. Continuing educating yourself, it is the most important thing you could do in this field. There's always stuff changing, the latest exercise, diets, fats, supplements, uh, training capabilities. You will have clients who want to know it all and do it all like right then and there. But the most important thing you can do is reassure them that the right now results are not the right results, if that makes sense. So being healthy, being cautious, being professional, that is what's going to get you the best outcome with your clients and knowing who they are and how their body works. For our next case, we're going to go over exercise equipment. So in a gym, you always want to make sure your equipment is properly working. If it's not, it is important to place an out of order sign on the equipment till it is fixed and safe to use again. Unfortunately, there are those rare occasions when a machine may malfunction while in use. In this case, it did not state the lady's name. It just says Harris County Woman versus LA Fitness International. So the plaintiff filed suit claiming she suffered bodily injury due to a treadmill malfunction at LA Fitness. The plaintiff was and is a regular member of the gym and had been going for several years. On this particular day, she was running on the treadmill and it malfunctioned. And it threw her from the treadmill, causing bodily harm. So the plaintiff indicates that LA Fitness never warned her of any possible dangerous conditions using the treadmill, and she was seeking monetary relief in the amount of $100,000. Businesses such as LA Fitness, they do have a duty to keep the premises safe for all. And not just LA Fitness, but all gyms, small gyms, the big ones, all of them. That is how we are going to keep our members and our employees safe. And to prevent malfunction equipment, to prevent equipment from malfunctioning in the gym, you really do need to run regular maintenance checks on all fitness equipment. It is very important. If a member lets you know a machine isn't working properly, it is your responsibility to make sure that that equipment is not in use until it is properly checked out, fixed, and safe to use again. Following safety guidelines when it comes to distancing equipment properly, avoid cluttering machines together. All of that will help when it comes to just in case a machine malfunctions that actually pushes you off of it, such as the treadmill. Um, Keeping all of the members safe, that should be the number one priority, and maintaining the equipment is definitely most important. Now, for our second topic here, we're going to go over employment law. Employment law, we're going to go over 3 case studies that pertain to racial and gender discriminations, wages, and gender equality. So for our first case, racial and gender discrimination, this was actually a class action lawsuit filed against 24 Hour Fitness for racial and gender discrimination. So this actually involved several races altogether. We had Latino, African American, Asian American, both male and female on races. However, there seemed to be more female plaintiffs that claimed discrimination regarding promotions to management positions and equal pay. In doing this, 24 Hour Fitness was violating the California Fair Employment and Housing Act and the California Business and Professional Code. The employees were seeking either promotions, back pay, and for a court order for 24 Hour Fitness to end its discriminatory employment practices. For our next topic, we're going to cover wages. In this case, you know, it's true, you take care of your customers and they'll take care of you. And this rule applies to your employees as well. And if you think that you can cheat them out of what is properly due to them for your own personal gain, that is not the case. Um, this here, 24 Hour Fitness, they had a class action lawsuit filed against them for improper wage calculation, including overtime and sales commission. I myself, at one of the previous gyms that I used to work at, I received a settlement for the same thing. And it's really striking to think that, your employer would be stealing money out of your pocket. It's not a good feeling, especially when you receive a nice little chunk of change. So, speaking on a personal note, it's not, you are not well respected by your employers when you do something like that. And it made me change the way how I felt about the people who I was working for. But so on that note, on here, the plaintiffs claim that 24 Hour Fitness violated section of the California Labor Code and the Fair Labor Standards Act. 24 Hour failed to provide meals and rest periods, required employees to work off the clock, classifying managers as exempt from overtime and improper wage stubs. The plaintiffs were seeking full recovery of lost wages, and 24 Hour Fitness, they had to pay everybody out was what was taken from them. In the next topic here is gender equality. When it comes to promoting your employees, the decision to whom you promote should be based on knowledge, experience, education, and performance. It should never be based on age, gender, marital status, and if you have dependents or not. Rachel Bronner versus Planet Fitness. The plaintiff filed a complaint with the Federal Equal Employment Opportunity Commission indicating she was wrongfully passed up for a promotion and terminated based on race and gender. When defendants Planet Fitness was asked why plaintiff was looked over their responses, when plaintiff why she was looked over, their response was anything but professional. A man with a family deserves to be paid more than a younger single woman. I don't know about you, but that's very insulting, especially when you have the education, the background, experience, and so forth. So Planet Fitness decided to settle their lawsuit for $25,000. However, they still denied the alleged discrimination. So going over these three cases here, we want to find ways to, avoid these scenarios. Obviously, they're very common sense. However, in I guess certain scenarios or situations, when people have power or some form of it, sometimes they misuse it, unfortunately. So strategies to mitigate these type of employment issues obviously is not to do them. That would, rule of thumb. But there is specific guidelines to follow for the state that you're in, and one of them is the Department of the Fair Employment and Housing. They're responsible for enforcing state laws that make it illegal to discriminate against a job applicant or employee because of a protected characteristic. So basically, when running a business, there are several guidelines that you should follow, and the DFEH is one of them. And if you go to your local labor board or your state labor board, they will inform you of what you can and cannot do, what laws protect you and what doesn't. And to be honest with you, running an honest business will have far more rewards than cheating your clients and your employees out of money. Discrimination is never acceptable. Neither is sexual harassment. or unethical business practices. You know, when dealing with a situation that may be uncomfortable for you or others, try to find the best possible outcome that sees fit for all. You may not be able to please everyone. However, being honest, professional, and caring will more than likely have a better outcome. So it's very important that when you do become a business owner or a manager, that you find out what uh, you are supposed to be doing, because if you don't know, then it may get you into a bit of trouble. And this way, that when you are running a business and you're making sure that your employees know that discrimination is never acceptable, that you offer the sexual harassment courses, that way there's no misunderstanding on what was said or anything, because those courses will clearly state what is appropriate and what is not. You train your employees to be honest and forward with their clients and speak to them with professionalism. And doing those things and abiding by those rules should lead you into a safer and more professional business practice. Application and faith integration. Um, we're going to go over what my future career looks like, 3 biblical references, and legal issues, and God's Word. So, applying sports law to my career, my ultimate dream would be one of 2 things, or even both. I would be to own my own fitness center one day and to teach elementary physical education. Just because I think it's so important for the little ones to learn early, and it'd be so much fun to teach them different things. It's because it's not working out to them, they're just playing. So um it's a lot of work, and maybe I will only accomplish one and not the other. However, I do believe that God has led me down this path for a reason. um in doing this, I know there is a lot of legalities that I need to learn and know. I am grateful for this class because it has given me a sneak peek of what laws to abide by and what not to do. uh Ethical business practices is one. Avoiding discrimination at all costs, compensating properly. Honest business practice is the best route for everybody. Make sure your staff is properly trained and abides by all ethical business practices, and know your laws. 3 biblical references that I found would be fitting for leadership, management, working with one another. My first one is John 7:16. Jesus answered them and said, "My doctrine is not mine, but his that sent me." I take that into account, as I do not write the laws. However, I do need to abide by the laws. And for this, running a business, I definitely need to abide by what was written by somebody else and follow that. And whether it be encouraging, to reference my Bible or the law or both, they'll definitely help keep me in my businesses aligned properly. Proverbs 28:6. Better is a poor man who walks in his integrity than a rich man who is crooked in his ways. Being dishonest about, what a client's supposed to pay, when their monthly dues are up, and cheating them on their sessions, it's all bad. It's not a way to run your business. It will catch up with you. Taking money from your employees, it will catch up to you. And there's no way to run a um, great establishment when you're doing things that you're not supposed to be doing. And my last Bible verse is Thessalonians 5:11. Therefore, encourage one another and build each other up, just as in fact you are doing. I love this verse because I have worked with some amazing, amazing bosses and trainers who really taught me the ropes. And I do the same in return. I honestly feel that in order to have a strong foundation, you have to share your wealth with others. And that is encouraging them to learn and prosper and be the best trainer, person, individual that they can be. And when you do that and you lead by example, I feel like the rewards are endless. God's word and legal issues. Now, we all know that this day and age, the world's a little crazy, and not everybody is a believer in God. I also understand that there are many people that are offended by the topic or even a reference about him, especially in a place of business. My motto is keep it professional, meaning if somebody doesn't agree with what I am saying about God, I will not pursue them with insult or malice. The goal is to show God's grace and love. I know that I can face legal repercussion for speaking about God, which should never be, but unfortunately, in this day and age, it's very true. What I would do and how I would continue my practice would be to know and speak with and find out the laws where I'm concerned about what I can and cannot say. Um, I will always promote God because He is the one who saved me and has led me down this path. Now, the way I do it, it doesn't mean that I'm going to boast or shove Him down everybody's throat. No, not at all. But I do make reference even now to my clients when they're feeling sick. I tell them I'm gonna pray for you. When something's gone wrong and they're having a difficult time, I've asked them if they've prayed or if they would like to pray. And luckily, I've had one incident where one of my clients made it clear that she did not want to talk about it at all, and I left it alone. I let her be. And then later on, I prayed for her. So, I feel that, when we talk about our faith or share it in a loving manner, people can be more receptive to it versus us, um, forcing it upon them. And like I said, I would definitely find out what I can and cannot do. And if there was a form of legal issue where I could be doing something I'm not supposed to be doing because I'm speaking about God, then that would be kind of hard because I do tend to share my faith and I don't have anything to be ashamed of for that. So here are my references. I'd like to thank you for taking the time and going through my PowerPoint and listening to my presentation. I hope you have a blessed day. Thank you.